I like your vote.
Yeah.
You're on the record. In the matter of the people of the state of Michigan, I'm sorry, City of Lansing versus Thomas Atkinson, 24-03754. Council appearance.
Brandon Waddell on behalf of the city of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lawrence Sutter, appearing on behalf of Mr. Atkinson, who is standing to my right.
Today is the date set for a pre-trial on trespassing. How are we proceeding on this?
I believe Mr. Atkinson is prepared to plead to the charge. The parties have covered for time served, which I believe he has 6 days.
And Your Honor, I believe specifically this is going to be a no contest plea, lack of memory due to intoxication. We have submitted a police report to your court staff for that. And that is correct. We've made an appeal agreement for 6 days, our time already served.
How did we get 6 days?
He was arraigned on January 6th and held in this case until January 13th when he was released. So that's why I came to that math.
We let an interim bond the entire time.
The interim bond, Your Honor?
It says continue interim bond. She never gave. She was never held on this. What she put on the top file at least.
Would the court accept the one day he was in custody for his arraignment? He was held at least overnight, so we would have at least that one day. He was, according to what I've been able to find on this case, I've limited information about his custody status there, but he, according to the online ROA I was reviewing, he was arraigned on the 6th and his bond posted on the 13th is what the ROA indicated. He was released at that time. So if the court can't accept the 6 days, would it accept the one day that he was in custody for the arraignment?
Yeah, it says in here, they stamp released on personal recognizance bond on the 12th.
Yeah, but his arraignment was on the 6th.
I see that. I'm trying to understand why he was held. Yeah, I don't know why it's held. No problem. That's fine. Okay. Was there a you said there's a police report?
Yeah, Mr. Waddell sent it to Yolanda and Addie.
Oh, it's in my email.
Yes.
I don't think I got it yet.
Oh, yeah, Mr. Waddell sent it to
Yolanda
and me.
didn't send it to her.
For the interim, sir, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. Okay, in this matter, you have certain rights that you would have to give up if you wanted to plead no contest. That first includes your right to be considered innocent until they prove you guilty. You understand that, right? You have the right to require that the prosecution prove each element of the charge or charges being brought against you beyond a reasonable doubt. You can remain silent at your trial and not have signs be used against you, or you can waive silence and testify at your trial if you like. You have the right to have witnesses subpoenaed to trial to testify on your behalf, and you have the right to see, hear, or question in court any of the witnesses that the city calls to testify against you. You understand each of those rights?
Yes, ma'am.
You're willing to give those rights up?
Yes, ma'am.
Is anyone threatening you to do that?
No, ma'am.
Any promises being made in exchange for you waiving those rights?
No, ma'am.
And the reason for the no contest, please, because you don't recall this incident,
Yes, ma'am.
and that was due to intoxication?
Yes, ma'am.
As to a trespassing, do you plead guilty, not guilty, or no contest?
No contest.
I have police report case number 25419122240. It alleges that on or about December 25th at 1:58 in the morning till Christmas morning, officers was dispatched to the area of 601 North Larch Street, also known as the Outreach Shelter, for reports of individual refusing to leave. Staff advised that the individual was refusing to leave. That individual was in front of the door blocking other people from entering. That individual was identified as Thomas Atkinson. Area of 601 North Larch, City of Lansing, Indian County, State of Michigan. Any additional factual basis?
On your honor.
Nothing further, Your Honor.
The court finds the reason for the no contest plea to be appropriate, I'll accept your no contest plea. And an entry of guilt will be made by reading of the facts on the record. And for some reason, you have credit on here. It looks like one thing says that he was released on the 13th, one says the 12th. And then the bond said he always had a personal bond. So somewhere there was a major glitch in the system. Always speak up in there if you feel like the judge said I had a PR bond. Like, speak up.
Well, I was jailed on a different offense as well. I had.
Oh, so you're being held on something else. Got it.
I did time in accounting for that. So that's probably where the confusion comes in.
Makes sense. So maybe that's what's going on. Well, we'll credit you time served. And I'm assuming there's not a no trespass issue with
That
that.
has expired since then. It was a 30-day only because the police came out. He has since apologized to them and is back working with them.
I was gonna say, I see the address he gave us was there, so.
That's correct, Your Honor.
Okay,
He is now
sounds
back in favorable terms with them. That was only a 30-day trespass they gave him, and that
Sounds
has
good.
expired.
All right, you're all set for today, sir.
Thank you, ma'am.
You see Desiree Reynolds is here.
Is she, Your Honor? I haven't.
She's on.
Yeah, I'm here.
I have not had the opportunity to speak with her. I left her a voicemail yesterday. If the court would allow me a few minutes. Mr. Zuniga perhaps could.
Yeah, I don't know who let her, they let her in and didn't tell you that she was here. She was here when I got here, so. Let's see. Mr. Zuniga's ready to go?
He is, Your Honor, and I've already filled out an application for the public defender's office with him. I'll just get his PV date after I'm done talking to Mr.
Oh, it's in a record. Okay, on the records. In the matter of the people of the city of Lansing versus George Zuniga 24-01453. Mr. Zuniga, this is a date set for an arraignment. I do have a couple of violations here. Requested summons for probation violation. This was dated for February 3rd. Alleges that you violated the terms of your probation by violating the amended order dated for January 14th, 2025. Defendant ordered to submit to Scram Tether as directed per JSG on January 21st, 2025. Scram confirmed tamper event received. Tamper event began at 8:05 p.m. on January 20th, 2025 and ended at 9:47 on January 22nd, 2025. And then there was another violation signed for February 3rd, 2025 that states that the violation of failing to refrain from alcohol per JSG Scram Tether confirmed a tamper event that began at 11:46 p.m. on January 27th and ended at 6:13 in the morning, should be February 1st, 2025. So you have the right in these matters to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you're found to be in violation of your probation status, your probation can be revoked and you can be sentenced to do just straight jail time. You understand that?
Yes, ma'am.
Did you want to request an attorney? My understanding is that you did.
Yeah, because I haven't done nothing.
So we note that you're pleading not guilty, you're requesting an attorney. You've already met with the public defender's office, so we will set this for a hearing. February 25th at 1:15. February 25th at 1:15. Get your copy of your notice to appear and then you'll be all set for today, okay?
Okay, thank you, ma'am.
You're welcome.
Sorry.
You're Stephen Schwab?
Swap.
Schwab? Did you request an attorney?
Yes.
Okay, my understanding is that you were denied public defense for some reason. Are you employed? When were you last employed?
It's been a couple of years.
Exactly. Thank you. Okay, well, we'll have the public defender meet with you again. For some reason, you were denied and they didn't explain why. And if you're not employed, then unless you're a trust fund child, I don't know how you would not be eligible. So we'll have them come back and meet with you and get some further information about your finances, okay? Are you being held? You're also obviously being held in Eaton County on something else, correct? Okay. On the record, in the matter of the people of the city of Lansing versus Desiree Reynolds, this is 24-03. Ms. Reynolds is having a conversation. Does she need to come back later?
Sorry. Yes, I'm here.
Okay. 24-03543, council appearance.
Brandon Webber on behalf of the city.
Good afternoon, Your Honor. Assistant Public Defender Lawrence Sutter, on behalf of Ms. Reynolds, who brings us notice.
Okay, Ms. Reynolds had a no ops in possession that was scheduled for today. How are we proceeding on it?
I'll defer to council.
Thank you, Your Honor. Ms. Reynolds is working on getting compliance with her license. She has to do an eye assessment with the Secretary of State. She had a seizure a while back, so she's recently completed that, gotten clearance to her doctor. She's completed that assessment. She's waiting on paperwork to come in the mail. We'd ask the court to give us 30 days to make sure she gets that paperwork and is able to complete that assessment. After that, she should be able to have the license fully reinstated.
We'll reset this matter.
Thank you.
March 11th at 1:30.
March 11th at 1:30.
Okay.
You have any questions for the court?
No, ma'am.
Any additional matters for the record?
None, Your Honor.
Nothing further.
Okay, you're all set.
Okay, thank you.
You're welcome.
And Your Honor, just before I talk with Mr. Schwab, for Mr. Zuniga, what was his probation violation hearing date?
February 25th at 1:15.
Thank you very much.
Would you?
So then probably reset this one, is that or after you speak to him? Mr. Schwab?
My office would probably tell me I should do that, yes.
Yeah, it's a him instruct. I think he has something set with Buchanan coming up.
Yeah. It's this week, though.
Oh.
Yeah.
Doesn't make sense.
No. Does he swing with our office? Because I don't have any active files in public defender system
It was,
across the board.
it was denied on that one too.
Yep, that one is also Judge Buchanan. State file is also closed with denial. I'll talk to Steve.
Twenty-fifth.
This one?
1:30.
February 25th at 1:30.
Yeah.
Okay, it's February 25th at 1:30 for him. Someone here? just joined on an iPhone?
Yes, Kimberly McLeod.
On the record in the matter of the city of Lansing versus Stephen Schwab, 24-02292, Council Jan.
Vernon Wandell, on behalf of the city of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Schwab, who is currently seated in the jury box.
Okay, Mr. Schwab has a pretrial today for hinder obstructive pose an officer. What's there on offer?
Mr. Schwab to plead to the charge when the parties have a co-agree for time served.
That's correct, Your Honor.
That's how you want to proceed, sir? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Okay, you can put your hand down, sir. You have certain rights that you would need to give up if you wanted to plead guilty to the charge. You have the right to be considered innocent until proven guilty. You have the right to require the prosecution, which is the city attorney's office, prove each element of the charge being brought against you beyond a reasonable doubt before you are considered guilty. You understand that? You want to give that right up? You have the right to remain silent at any trial and not have silence be used against you. You have the right to see, hear, or question in court any of the witnesses that the city calls to testify. You can have witnesses subpoenaed to testify on your behalf. And you also have the right to waive your silence and testify at your own trial if you like. Those are all also rights that will go along with waiving your right to trial. You understand that? And you want to give those rights up? Is anybody threatening you to give those rights up? Any promises being made in exchange for you pleading guilty today to the original charge? And are you pleading guilty because you believe you're guilty? Okay, as to the charge of hinder, obstruct, and oppose an officer, how do you plead? Factual basis, counsel.
Thank you, Your Honor. If you'll allow us one moment, we're trying to get a police report to cooperate with us.
No problem.
Yeah, just.
Is the report still not working?
Yeah, he's having some trouble getting into phone button. Would the court like us to step aside for a minute and handle something else while we get this to cooperate with us? Or?
No, I'm just trying to see if the affidavit of probable cause says what happened. This is
I
gonna
know the
be-
general gist is he was told to stop and did not.
It's gonna be the longest affidavit of probable cause I've ever seen on the city, man.
Some of them get a little wordy, don't they?
Okay, let's see, Mr. Schwab, on or about August 1st, 2024, were you in the area at or near 580 West Mount Hope?
Yeah,
I'm sorry,
yeah.
is that in the city of Lansing, Ingham County? Okay, and you had a interaction with law enforcement? At the time, did you engage with Lansing Police Department?
Right.
Okay, and did they give you a lawful order to stop? Is that a yes? I can't hear you.
Yes.
Okay, and did you obey the order? You did obey the order?
No, I did not.
Oh, you did not obey the order. Okay. Any additional factual basis?
I'm satisfied, Your Honor.
The court is satisfied with the factual basis. I will accept your plea and find your plea made freely, voluntarily, and intelligently. Looks like you were originally arraigned on this on the 13th, and you had a 10% bond. So credit time served. You're all set.
Thank you, Your Honor.
It did, and then it did this.
That's good.
I don't know what's.
Mr. Harding will reach out to you for your Thursday, case, okay?
That's all the city matters now.
You so, Your Honor. Have a good rest of your day.
Thank you.
Thank you for letting us come back on and do that.
Okay.
Z2 Holdings versus Kendra Davis, 24-03443 GC, council appearance.
Good afternoon, Your Honor. John Hintz, P 47968, appearing for the plaintiff Z2 Holdings. This was the time and date set for a show cause hearing.
I don't see anyone present for Kendra Davis. There's no one in the hallway, correct? Okay, no one has appeared for Kendra Davis. Mr. Hens, how do you want to proceed?
Thank you, Your Honor. As we were here on January 3rd and Kendra Davis did not appear, and as we're here today, and again, Kendra Davis has not appeared. She's been served. And Your Honor, with that in mind, we respectfully ask this court for permission to submit a bench warrant. And the amount of the judgment was approximately $3,600. So if the court would issue or grant a bond, I will prepare the bench warrant and submit it to the court for its review.
Bond can be 10% of the judgment amount.
Thank you, Your Honor. I will prepare that and submit that to the court.
Thank you.
Thank you, Your Honor. That's all I have. Have a good day, Your Honor.
Same to you. Having a trial, they're playing evidence. I had another one. I'm about to screen. That's your emails? Yeah, just stay on top of them. Breaking news. Okay, Blanchard. I don't know. Okay. Be on the record in the matter of Discover Bank versus Thomas Blanchard, 24-074, I'm sorry, 7574. Council appearance. You're muted.
Apologize, Your Honor. I didn't realize that. Michael Spolman, P41216 of Counsel for Buckles and Buckles for this afternoon's hearing on behalf of Discover Bank.
Okay, and so are you Mr. Blanchard?
I'm sorry,
What's your name?
Thomas
You can
Blanchard.
stand up, sir. You can stand up, sir.
Oh, thank you.
Okay, you're Mr. Blanchard, and this is your motion. Are you filing a motion to set aside a default judgment? Default judgment was entered after you failed to appear. You indicate that you missed the court date and error. You put it in the calendar for the wrong date.
I misread it, yes, Your Honor.
Okay, and so that happens. The court rules, however, do require that before I can set aside a default, you have to give me good cause, which you've given me, but you also have to give me a meritorious defense to the case, meaning, do you have some defense to the actual lawsuit that has merit?
Well, yeah, actually, in September of 2023, in an effort to avoid bankruptcy and to eliminate my debt, I enrolled in a debt resolution program with Century Financial. And I had named Discover Bank and a few other creditors to the program. And it was my anticipation, pardon me, that Century would negotiate a settlement with Discover Bank like they had with the other debtors or creditors, pardon me. And of course, it appears that didn't happen, whether it was on, Century's end or on Discover's end, not willing to negotiate. But over the last, almost a year and a half, I've made bi-weekly payments to the program. I have not missed a payment, and I've brought one of my debts, which was over $8,000, down to about $1,500, and down to 7 more payments. And I'll be clear on that. 2 other debts I've reduced dramatically as well.
Let me stop you here.
Yes, ma'am.
Because I'm just trying to get some clarification, because I know your answer, this is the quasi point to what you say in your answer, that you enrolled in a debt resolution program with Century debt settlement to avoid bankruptcy. You said Discover Bank was named as a creditor.
They were.
Okay, so are you Have you confirmed whether or not they were a part of the debt resolution or were they not?
Well, I have not. I mean, it shows on my summary
That they
from,
were included?
that they were included.
Okay, well then that's a meritorious defense.
And so
That's all I'm gonna stop you there while you're ahead.
thank you.
Thank you. Okay, counsel, did you want to respond?
Thank you, Your Honor. With regard to and I appreciate the gentleman has enrolled in the debt settlement program. And while he is apparently making some headway on that, for which obviously is commendatory, I don't think that rises to the level of a defense to the action. My point in that is number one is that the plaintiff, while the defendant may choose to engage someone to assist him in resolving his debts, the plaintiff in these type of actions, to my knowledge, is not required to negotiate with them. They may choose to do so, but they are not actually required to do so. And the mere fact of his enrolling in that program is, I don't think, an underlying defense to whether or not he actually owes the money or not, which is the issue in the case. So, Judge, that would be our response, that there is not a valid defense here, and therefore any judgment previously entered should not be set aside on that basis.
Thank you. And I've already made the determination that I find it to be a meritorious defense, and that's because of the fact that if, in fact, almost 2 years ago, he has enrolled in a debt settlement and has been making payments, and his understanding and the information that he believes he has includes Discover Bank as being a creditor that was involved in that structured settlement, then that would forbid Discover from now going outside of that settlement agreement to try to sue him. And so because neither of you have information one way or the other to tell me if that absolutely is not the case, then that means that this needs to move forward so that we can figure out whether or not this is a matter that was involved in the structured settlement. You may later find out at the next court date, which is going to be a pretrial date, that they were not included. If that's the case, then maybe you need to you'll agree to some other resolution with their attorney. Or we may find out that they were also already included in that they're receiving payments under this structured settlement. And then the court will resolve it if that's the case in another manner. But nonetheless, based on your ability to provide good cause as to why you have missed your court date and a meritorious defense, I will grant your request to set aside the default judgment. This matter will be set for a pretrial. You'll get your next court date in the mail, and your address has not changed since the time that you filed your motion, correct? Sir? Your address has not changed, correct?
I'm sorry.
Has your address changed since you?
No, ma'am. No.
Okay, you'll get a notice in the mail. Do you have any questions?
I do not, thank you.
Okay, you're all set. Thank you, counsel.
Your Honor, one final question. Just will the court be issuing an order setting that aside, or is it sufficient for the court's purposes that it's noted it on the record?
The court will issue an order setting it aside.
Thank you, Your Honor.
Thank you. Thank you. Someone put me in order, please. I need an order. I don't know if I put that note in there. Atlantic Automakers versus Kimberly Woods, 96-000097. Appearance, please.
Excuse me, Your Honor. Good afternoon. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of plaintiff today.
Okay, and then I have Ms. Woods, now known as Ms. McLeod here. I believe that at our last date, there was a request for some information to be provided.
That's correct, Your Honor. Bank statements.
Okay, and Mrs. McLeod, did you provide that information already? We can't hear you.
Okay, hello?
I can hear you now, yes.
Yes, ma'am.
Did you provided those bank statements that were requested?
Yes, Your Honor.
Okay, Mr. Brunette, is that correct?
Not to our knowledge, Your Honor. We have not received them. I don't know if it was very recently that she sent them to us. But we did not.
Where did you send them, Ms. McLeod?
Where did I send them?
Correct.
Yes, at the address of P.O. Box, Traverse City, 705 Traverse City, Michigan 49685.
Okay, when did you send them?
I sent them on I got my receipt right here. Sent them from the post office. Just a moment.
What's the date?
Flat rate. Let's see. The 5th. I sent them from the 5th of February, and they were supposed to be delivered Friday the 7th. Delivery date. I sent it at a flat rate envelope. Expected delivery Friday the 7th.
Now, are you able to confirm?
Your Honor, I'm not able to confirm that we received them. It could be that maybe they're backlogged at our PO box, or I don't know. We haven't received them, so I don't know if it's appropriate, Your Honor, or acceptable to adjourn for a brief, I don't know, a week or so, for us to make sure that we do or don't have them.
And I also have the tracking number right here.
Okay, make sure you hang tight onto that so that in case they don't see it or receive it, you have something that shows it was sent.
February 25th at 2.
I'm gonna reset this for February 25th at 2 p.m.
Okay, Your Honor, will I get a paper in the mail for that?
Yeah, we'll send a notice in the mail to the address that we have on file.
Okay, Your Honor, I'd like to speak with you for a second, if possible.
Okay, you speak with me. We're here now. You can let me know what you want to speak about.
Okay. Last time when we were there, I believe it was the 7th, January. I forgot when. You asked me to go downstairs to the 5th floor and give them my doc number, which I did, and they looked up this account, and they didn't find a thing on it, the original at all. They just showed where every 10 years something he got in contact with me, reset or something, but they couldn't tell me what it was about. They couldn't tell me what it was for. They had no original copies of anything.
Okay, so you want a copy of the original copy of the complaint? Is that what you're looking for? Or the judgment? What are you looking for, ma'am?
Yeah, the original copy of what this is for.
Okay, so the complaint and then the judge, it's the complaint and the judgment is likely what you're looking for. And because this is a 1996 case, the court would not keep those records especially not in the building, because imagine if we had to keep every file from 30 plus years ago. We'd be burying files in this building. So if there's a physical file and there's a retention schedule that the court has to follow as to how long they keep a file, but if there is a physical file, it would not be in the actual courthouse, it would be in the storage. So I will know or contact Civil. I will let Civil know that you would like to see the file. That's what I sent you down there to see, for them to request the file. If they
didn't have
have
it. I'm
yeah,
sorry.
I recognize that they don't have one in the building, but I wanted you to also find out if they can request or go and get the original file. And if they're telling you that the file has been destroyed, then that's different. Then they don't have it. So I need to figure out if there's actual file or not, okay?
Okay. Because I just don't believe this is true. I don't know. I had nothing with LabQ. I don't even know. This is just like it came out of the blue. What is?
I understand your concerns, ma'am. So I noted, and I've also sent information to the civil department so that they can get a copy of the file if it's available, okay?
Okay.
So we should hopefully by your next court date have an answer as it relates to that, okay?
Yes, and I'm gonna there's a tracking number, and they guaranteed that those business forms that I sent was gonna be there by Friday. And I don't see how they don't have them.
I will
And-
double
Don't see
check,
how they
Your
would
Honor,
have one
and
either, but it's Tuesday, so I don't know if maybe it got delivered yesterday and maybe a council didn't get to his PO box yesterday.
And I don't think, I haven't had any dealing with them, I believe, since 1978.
Dealing with
With
who?
LabQ. With LabQ. I couldn't think of anything as far as that.
Okay, I understand that, ma'am. But we'll see if we can get a copy of the file so we can figure out what happened here. And I don't know if Mr. Smith has a copy, I don't know. But we will see about getting a copy of the physical file if we have it in storage for your next court date, and then we can provide you with a copy of it if we have that in person, okay? And then you hold on to the receipt that has your confirmation number.
Yes.
My inclination is that based on when you mailed it, it probably did get there on Monday, maybe. And today's Tuesday, and maybe Mr. Smith's been away from the area to go to the PO box. So we're
yes,
all
Your
set.
Honor, I will look around and make sure that it's not on.
Okay, I have a meeting in like 5 minutes. Okay, thank you. You're all set for today.
Thank you, Your Honor.
Thank you.
Thank you. Thank you. Let me see, copy of physical file. Is there anyone else a pre-trial? Okay, I see a Velocity. Ms. Kuhn, you here for Velocity?
Yes.
Okay, anyone here by the name of Rose Henderson? I don't see Rose Henderson here. Okay, let's see. Rose Henderson has failed to appear. How do you want to proceed, counsel?
I would like to ask for a default judgment.
By default, it's granted. You can file the paperwork on my file.
Okay.
Thank you. have a note that they were here. Oh, that-
Must have never filed the joint pre-trial statement. I just said in September.
Yeah, I had a note in September, but now I guess they never filed the joint pre-trial statement.
Or order the change in the pre-trial statement, order it into pre-trial schedule for trial adjourned, and then it was rescheduled to the 11th.
Yeah, I don't see a joint pre-trial statement anymore.
Because it was scheduled for another. I don't know.
Okay, LVNV funding versus Roberto Rodriguez. I see Mr. Rodriguez
Good afternoon,
here.
Your Honor. Andrew Cates, P78292 for LVNV.
Okay, Mr. Rodriguez is present. Today's a pretrial, so I'm gonna put you both in a private meeting room so that you can do your joint pretrial statement. It'll need to be signed by both parties after it's completed, and then counsel would be responsible for filing it on my file. Or you can also come to resolution during this time, okay?
Thank you, Your Honor.
I'm gonna put you in room 1. Okay, absolute resolutions versus Justin DeBoer. 24-07696.
Good
Are
afternoon,
you gonna
Desiree.
stand here?
I say something?
Yes, what do you want to say?
Last night I made payment arrangements online to settle this debt, and I'd like you to see this.
Counsel, did you receive notice that he's made payment arrangements? Who did you make payment arrangements with, sir?
It's all right
I'm
on,
not asking to see, you tell me who you made payment arrangements with.
Web Bank Advance, and the current creditor who's a debt, is called LVNV Funding LLC.
For what's the balance of the debt?
The balance is $1,348.
Counsel?
This is for Absolute Resolution Investments, and it was on a loan for $2,983.83.
So it's not the same debt?
No.
So is this in regards to Web Bank?
Web Bank was the original creditor, yes, but this is Absolute Resolution Investments, not LVNV.
Then
Okay, so you had a debt with whom?
it was supposed to be with Avant, Web Bank, and I got told by a debt collector from them that I can make payments, $100 a month, but I guess like the debt went to some other creditor after that.
Well, you can't have two different entities collecting the same debt. So,
Yeah, I'm confused.
yeah, I am too at this point.
The balance is different than what you mentioned.
Is there let's see here at the board. Let's see, who did Absolute Resolutions take over a debt for?
The original creditor was Web Bank. I'm trying to pull up the complaint to see the attachments. One second. Yeah, it was Web Bank for Avant loan. The amount left on it, the balance is $2,983.83.
I don't see any attachments on our complaint. Let's see here.
Normally we attach things, but let me pull it back up.
let's see here, web loan, web bank loan, promissory note. What is the date of the loan, sir?
The date when I got the loan, let's see, I do not remember exact date or had the paperwork with me, but it was, I think it was like back in 2023, around maybe probably May. I could be wrong.
Your paperwork that you have there doesn't tell you the date of the loan.
No, it just says, the current balance and the creditor and account number. I mean, I would have to, like,
It gave you the creditor and it gives you an account number?
yeah,
What is can you provide the last four of the account number?
it is 3972.
I have a different account number. Um, did you maybe take out two loans?
No, it was one loan.
Okay.
And this is like the original creditor that contacted me and making payments, and then I arranged it online. And would you like to see the paperwork I have about it?
What was the account number again?
It is 80467
Oh, just
397
you can just give me the last four.
Last four digits.
3972.
Okay.
Can we
I-
have an
I have-
8368 last four digits?
Yes.
You have a different account number.
And I have a different year on opening of 2022.
I have 2022 as well. Well, I have the complaint, which is what they have. We have a different account number. What I think, well, this was a pre-trial anyways. I'm gonna have you put it going on Zoom so you can meet with her privately and talk to her about whatever that is that you have there.
Okay.
And then you can get her information so you can send her a copy of what you have, okay?
Okay.
And then if they're able to determine it's the same debt, then they can resolve it one way or the other. If it's a different debt, then we need to move forward with your pre-trial on this debt. Because this one says you owe a balance of 2,900. What was the original loan amount on your debt you had there?
On this paperwork?
Yes.
It says original balance $1,348.25.
No, not the original. That's how much did you take a loan out for?
It was like for $3.
3,000?
Yeah.
What does it say on there?
On here, it says the balance is, $1,348.
Okay, and you did that through web bank
Yep.
directly?
Mhm.
Yeah, because on this, I see an exact amount as to what your balance originally was.
Yeah, I've been, I paid it down a little bit, and then, I lost my job, and then the interest stacked up, and then now went back to owing that amount again, which fortunately it
Okay,
happened.
we'll get you on Zoom so you can meet with counsel, okay?
Okay. Thank you.
Okay, counsel, did you and Mr. DeBoer discuss a pretrial statement at all, or are you still working through his information that he provided?
I didn't talk to him about the pretrial statement because he wanted to make up a payment arrangement. So we discussed payment arrangements and came up with an agreement on that.
Okay, are you going to file that agreement?
I'm going to send him a copy for signature and then file it, yes.
Okay, sounds good. Do you have any questions today for the court?
No, I don't.
Okay, then you're all set. They will get that to you. You can review and sign, and once it's sent back to them, they'll file it with the court for my review, okay?
Okay, thank you.
Did you want to put the terms on the record at all, counsel?
Sure. We agreed on the principal damages of $2,983.83, court costs of $128.25, statutory attorney fees of $75 for a total of $3,187.08. Defendant will make $100 monthly payments beginning February 14th and continue on the 14th of each month thereafter until paid in full.
So that's accurate as to the agreement that you want to enter into?
Yeah.
Okay, any additional matters for the record, counsel?
No, is it possible to get a control date in case I don't get a signature back or he changes his mind?
Absolutely. We can reset this pre-trial 30 days.
Okay.
Let me get your date now.
Okay.
March 11th at 2:30.
March 11th at 2:30.
Okay.
Okay, we'll get you a notice for that control date. You don't need to appear as long as you sign the paperwork and send it back, okay?
Okay.
Before that date. You only need to appear if they don't get it back, okay? All right, and if you're not sure if you need to appear, you can call the civil clerk's office prior to that date, okay?
Okay.
All right. Let me get you a notice and you're all set.
Okay, thank you.
Thank you. I don't know why it won't let me leave a note in here. Tweaking. And you know who did not come back? AJ. No, I thought I heard us. I jumped off the bench. Okay. I see Mr. Rodriguez is back and Mr. Katz is back. Did you all complete a joint pre-trial statement?
Your Honor, we're really unable to because for whatever reason, Mr. Rodriguez can't seem to get his audio to work.
Mr. Rodriguez, can you hear us?
He says he can hear you, but he has to like chat everything.
No, I'm gonna reset it. He'll appear in person. February 28th. February 28th at 2 p.m. Defendant will appear in person.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
No, Your Honor.